Good morning, I'm Bud West, a former quorum court member for 8 years. And I wanted to talk this morning about the continuing policies of the city of Hot Springs. And I want to preempt that by saying I love Hot Springs. I love Garland County, but I think we can do a better job by working together. And about 5 years ago, I was a member of the Criminal Justice Coordinating Committee as a member of the Garland County Quorum Court, and we all got together and built a new jail. Recently, another tax initiative has been passed to extend the bypass over to the Fountain Lake area and do other road improvements around Garland County. And that's all been done by working together, and I believe in that wholeheartedly. As most of you know, the City of Hot Springs has modified their ordinances and policies and continues to disallow water service to new users outside the city limits. This ordinance and policy has and continues to have devastating impacts on property owners and economic development in the county. In fact, this policy alone has stopped all significant growth in the county outside the city limits, including several proposed new subdivisions, several apartment complexes, and numerous new businesses. For example, a new Walmart supercenter that would have employed over 480 persons directly, plus many others indirectly, was turned down. This policy has significantly lowered the values of our citizens' properties. Who wants to buy property that has no water or sewer service when it's available? This in turn lowers the tax base of our county, which greatly impacts our ability to provide basic services. For these reasons, we are here today to request the City of Hot Springs immediately rescind their ordinances and damaging policies prohibiting water and sewer services outside the city limits. Further, the purpose of this press conference is to inform the citizens of Garland County, Arkansas, that the City of Hot Springs and its board members, we feel, are in direct violation of a court order which has already ruled that the city must stop such practices because they are illegal. Now, I'm talking about a consent order of 1994, and I've got it right here. Specifically, the court order titled Consent Order Number 93-1639, filed on November 3rd, 1994, deals with city violations concerning annexations and water and sewer connections outside the city limits of Hot Springs. The court found, and the city agreed to it, to facts that found the city board of directors and the city guilty of violating the Constitution of the state of Arkansas and enforcing illegal resolutions, policies, and actions. These included Resolution 2821, which violated Article 3, Section 2 of the Constitution of the state of Arkansas. This pertains to voting rights that were denied to citizens during annexation by city practices. And here we are again. And denying the right to vote is terrible to me. In driving over here a little while ago, I see signs everywhere, political signs that say, "Go vote, vote for me, vote, vote, vote." It's everywhere. There's voting right down the street right now. You have a legal right, a constitutional right to vote, and that's being denied. Enforcement of Resolution 2821 and city policies and actions was found in violation of numerous agreements between the city and various water districts, sewer districts, and property owners living outside the city limits. The prevailing plaintiffs had paid taxes to construct water and sewer improvements and have relied on the city's promise and previous practices to allow connection to water and sewer with no prerequisites required. The city guaranteed in exchange for a grant from the federal government to construct new facilities that the facilities would be regional, meaning inclusion of outside of city users. No mention of preconditions were made in order to obtain federal funding and cannot be arbitrarily added. As a footnote to these rulings, Hot Springs now seems to be saying that the agreements between certain water and sewer districts dating back to the 1970s have expired. or they are otherwise not enforceable. We contend that were there many parties to the lawsuit other than water or sewer districts, which actually included and continue to include all property owners within Garland County. The court order obviously has not been overturned and thus remains in effect today. This court order stopped the city practice of requiring property owners to either annex to the city or promise to do so in the future in order to obtain water and sewer service. Furthermore, the order dictates the plaintiffs and property owners of Garland County relied on the city's promises and can enforce these promises against the city as third-party beneficiaries of the agreement. Consent Order 93-1639 specifically states in item 23, the defendants, that's the City Board of Directors, as representatives of the City of Hot Springs and agents and employees of the city, are permanently enjoined from doing any of the following. Any requirement by the city to annex or promise to annex by a property owner or other individual. Refusal to provide service irrespective of its location inside or outside the city. The court also ordered that all petitions for annexation and all pre-annexation agreements executed as a result of the city's illegal requirements are void ab initio, which means from its inception. Strictly interpreted, this means all annexations such as Chesswood, that's across Airport Road across the bridge on the left, that shopping center and numerous others are illegal, and these properties actually should be de-annexed. Does it not? CHS Ordinance 5931, Chapter 5, Section 1, B-4, Priority of Request. Any such request within the corporate limits of the city shall be given priority over projects outside the city limits. This consent order right here from 1994, I only have one copy today, but anybody that wants to look at it is certainly welcome to. And this spells out to me that people were denied the right to vote in annexations issues, and Judge Vicki Cook, who recently retired here in the courthouse, ruled at that time was in violation of the Arkansas State Constitution. And people have a right to vote, and that should not be denied. And the other part of this is withholding water and sewer service to people that are eligible for it where it's available is not right either. These policies cause problems. There's always been problems. Here we are in 1994 with the same issues basically that we have today. And I hope that something could be done about it.
In the 90th General Assembly, we changed a law that allowed the annexation of land that was sided by three sides of a municipality, and the fourth side, or the third side either way, fourth side would be of a water, a military base, another state, a lake, a river, something like that. It could be anything that would make that fourth side that would be a common ground. Well, that was a mistake. We made a mistake, and we took the rights away of our people to vote on this issue. Well, I have a draft legislation that I have just got it this morning, finished drafting it, that will give that vote back to the people. This is an act to amend the law concerning the procedure of annexation of surrounding lands and for other purposes. And it states in there an election will be called to do the annexation. So we're gonna try to get this filed. We can't file till November the 15th. We'll get this filed. It'll be in the 91st General Assembly. We'll see where it goes. I can't make any promises because there's 135 people that have to vote on this. So, but we're gonna give it a try.
I had to consider strongly whether to be here today or not, because I represent both Garland County and the City of Hot Springs. This is not and should not be a city versus county issue. Every person who has been part of a water district and has had their property assessed believed when they did that they would have water when they needed it. It's a matter of simple fairness. Beyond that, these policies have slowed down economic development in Garland County at a time when we couldn't afford for economic development to be slowed down. And we have to stop that. We have to change. And I'm grateful to those who found this court ruling, and we need to honor it. Thank y'all.
I think coercion by government is the last resort. We don't force the people that we serve into taxation without representation, and that's what this is akin to. I know the majority of my district lives outside the city limits, but we eat inside the city. We use city water. We pay those taxes every time we shop. And when it falls on deaf ears, and when there is no response, there is no one to appeal to. And that is where that's why we have to come back to ruling documents like this to say this is how we should behave. And so I'm appreciative of the people who did find the documents, that find the court rulings, and until that's overruled, then we go back to that ruling of the judge that says this is how we're to conduct business.
I really don't have a lot to say because basically I've been speaking loud and clear against this from the beginning. I think it's unfair to create a water shortage that was not there, an immediate water shortage, let's put it that way, that was not there to stop growth and development beyond the city limits. You know, I understand all the issues on both sides, but to not tell the truth, I think, was the wrong thing to do. They need to come out in the open with what the problems are and solve those problems. Water should never be used as a tool for annexation, and it should never be used in a political manner. And that's what we have here. That's the people's right of Garland County to have a clean water source and the sanitary living conditions. So to me, I think it needs to come out of the political realm. But basically, that's all I got to say. Thank you very much.
Okay, Mr. West, tell me what you think will result from what we just did today. What's your hope?
Well, I'm hoping by making everybody aware of what happened in the ruling from 1994, that when everybody reads this, they can feel like the city is for sure wrong at this time doing what they're doing.
Okay.
And that's denying in annexation issues the right to vote, even though legislation is passed, and you heard Representative Kazort say that they were anticipating trying to change that. But you know, what is the right thing to do? Is it right to deny people the right to vote, or you know, to me it's not. I mean, if you're going to annex up to 600 acres, which is one of their proposals, then those people living in that 600 acres and everybody else should have an opportunity to vote on it.
Now, I was at the last Board of Directors meeting for the city, and this was brought up during that Board of Directors meeting, and in fact, the paperwork that you got was handed to the city attorney, Brian Albright, who said that it was no longer valid. What in the world do you think that basis is on?
Well,
we can't find anything that's overturned it. Is that correct?
I don't know. You'll have to ask Mr. Albright.
Okay.
Yeah.
Okay.
I'm sorry.
All right. Well, thank you very much.
Well,
I
thank
appreciate
you. It's
the
been a
interview.
pleasure.
Thank you.
Very nice to meet you.
Thank you. You too.
Okay.
Well, I have George Pritchett here with me, and we were just discussing something a little bit interesting about our city leaders, and that is that they kind of selectively utilize laws. In other words, 1994 was recognized on something recently that we were just talking about, a 1994 ruling. But you're telling me that there's something else that goes back even further in regard to your lawsuit on annexation.
In this matter today, the consent order is a 1994 consent order.
Okay.
The city attorney has said, well, that doesn't apply. We litigated in 2006 or 2008, and that set that aside. We've consulted with attorneys and at least one judge and received opinions, not official opinions, that's not true, that is still in effect, and that's why we're gathered here today, that consent order of 1994. It is odd when you look back that on our referendum, on our signature petition to let the people vote, that the city ruled that we couldn't vote because we delivered it one day late, even though the most recent law, we believe, gave us 60 days. However, the city has interpreted we only had 30 days on the type of filing we did, which was a referendum. And they went back to a law in 34 or 48. So it's obvious that the city attorney and the City of Hot Springs picks and chooses what they want to use that suits their own needs without regard for the will of the people.
So those signatures were actually turned in at 31 days.
They were turned in at 31 days.
Wow.
The recent law in the legislature changed to give you 60 days. It was our interpretation for both referendums and initiatives. However, the city interprets that differently, and that's why we're in a litigation. It's costing the city of Hot Springs tens of thousands of dollars, along with about 20 other lawsuits.
Right.
That's probably taken them into the hundreds of thousands of dollars, because they're so darn hard-headed, they'd rather go through lawsuits than they would to let the people vote on anything. Thank you.
Pretty sad. Pretty
Very
sad.
sad.
Thanks, George.
You bet.